Your plaintiffs.
Good morning, Your Honor. My name is Luba. I'm here to represent myself.
Good morning, Your Honor. Angela Ochoa on behalf of Melvin Grimes and the Robert Stoppel Law Firm.
And Benjamin Childs, representing myself in the law office of Benjamin Childs.
Did you say Ochoa?
Yes.
Okay, Ms. Ochoa. All right. I think Ms. Ochoa and Mr. Childs, you can sit. I want to speak to, is it Ms. Dace?
Dace, that's
Okay. So Ms. Dace, the concern that I have here primarily are, one, litigation privilege is a strong concern. The next that Stoffel Law Firm raises based on what the documents you've submitted are that there's statute of limitations concerns, there were sanctions issued in the prior case, so there's double recovery concerns. If you could speak to me, generally, the issues that you're describing happen would be followed up in an appeal or a motion for reconsideration, or even if orders are granted, judgment is granted, final judgment is granted, you have 6 months to a year, depending on what has happened, to move to amend a judgment or order in that case. And it preserves that case and keeps the record clear as to what's going on in that case and allows you to put evidence in that case and keep your appeal clean. When you come into this court, now there's a whole different set of laws that come on because you're collaterally attacking the process in front of the other judge. And so, so when the appeal, like if you don't like my decision, the appeal that goes up from me doesn't have the record of the other courts. That's not in front of it. And it just changes the standard substantially to come into my court and challenge what happens over in family court, as opposed to handling it in family court, which is generally the proper venue for any kind of appeal or reconsideration or producing evidence of fraud, anything like that. That's all allowed under the rules in the other case. So I want you to speak to why this is not being done in the other case.
Well, we have filed, pardon me.
And you're welcome to sit so you can be closer to the microphone.
Okay,
That's
thank
fine.
you.
Sure.
So we have filed the appeal, which is in process right now. I filed this case specifically against Mr. Grimes for abuse of judicial machinery. I know you mentioned that he said that there is a statute of limitations has gone by. However, his conduct from 2021 continued, and this is his misconduct is from 2023 when he injected abduction rhetoric into hearing noticed only for contempt and custody modification. Additionally, he knew that there was a stipulation between himself and the co-defendant, Mr. Childs, that certain things had to be met by my ex-husband before the child exchange happened. His own client, my ex-husband, testified that yes, there was a stipulation. Mr. Grimes denies that there's a stipulation. However, his co-defendant says that it is undisputed that there was a stipulation.
Okay. Anything else?
As far as what my complaint about Mr. Childs is, so Mr. Child relies on anti-S.L.A.P.P. and on litigation privilege. Nevada law is clear, the lawyer cannot use the litigation privilege against his own client in malpractice or fiduciary duty claims, Greenberg, Trierick versus Frias Holdings. So my claim against Mr. Childs that he neglected his fiduciary duty to me when I asked him to testify and speak the truth about what happened and his advice to me pertaining to withholding the child, and he went under oath and he used my confidences against me. So lying under oath is not protected.
Right. So speaking specifically to that issue, even if litigation privilege didn't apply because he was your attorney, The issue is that if he gives false testimony in a certain case, it's that judge's responsibility to handle that sanction. So that judge in family court, was it, what department? Heidi Almase. So Judge Almase has the authority, if she finds that he's giving false testimony, to sanction him, to refer him for prosecution, refer him to the bar, refer him to any number of things, or sanction, anything like that. She has authority because, or to hold him in contempt of court, because that's all happening in her courtroom at that time. Even if you discover afterwards that it's false information, that's why I say the rules allow you for 6 months to a year, depending on what the false statements are, to file for a motion to amend the judgment or order in front of Judge Almase. And she has the whole record in front of her. She's the one who received the testimony. She's the one who can make findings as to his credibility. But for me to go back and check it now, that's a collateral attack on the process that happened there. And so that's the problem I have in this jurisdiction, in my court. And so was there any, after the judgment was entered, I know you appealed it, was there a motion for reconsideration filed or a motion to amend the judgment or order filed?
We filed with Heidi Almasi motion for reconsideration, but that she denied that motion. So then we proceeded with the appeal. And we are waiting now on the appeal decision. However, I did suffer damages, which I lost my joint physical custody of my daughter, and I was made a visitor in my daughter's life based on Mr. Grimes's and Mr. Child's actions, based on them misusing the law and the system. Mr. Grimes is punishing me for being held in contempt of federal court for violating an automatic stay. And his firm had to pay out a certain amount to my attorney. I'm only bringing that up to show a pattern of his misconduct and his misuse of judicial machinery.
Okay. Anything else you'd like to say?
I'm probably over-prepared. I have the plaintiff's exhibits. I don't know if this would be the time to give them to you or.
You can give them to me if, were they the ones that were already filed?
Yes.
Yeah, so I already have those.
You already
So
have
don't
this,
need
okay.
provide those to me. So, Ms. Ochoa.
So a couple of things, I just want to address some housekeeping issues before we move further. One of the things that she had filed was an objection to my reply, saying that it exceeded the scope of the motion and that she wanted it stricken. I request that you overrule that objection. The case law that was provided was not on point. This is what we're here for. We're here for oral argument to discuss whatever matters were brought up in the reply. She has the opportunity to discuss those. So I don't think that's that I respectfully request that you overrule that objection. Another housekeeping issue is there's a couple exhibits that she asserts supports her position. I could not find it anywhere in the documents. I think it was her exhibit N and then exhibit S. I don't know what those were, but they were not in the file documents. So just beyond that, it's just generally everything that's in the motion. So unless you have any specific questions.
I do not. Let me just respond. Go ahead, Mr. Childs.
I'm going to use the podium.
Go ahead.
Thank you. So I got some housekeeping matters too. I brought it up in my reply about there's so many things that are filed. And I don't know, I'm asking the court.
It's supposed to be hooked onto the top, so, right? So if you just slide there, perfect, yeah. That won't fall off.
So, for instance, I don't know what, well, first off, could we just clarify before we end the hearing, it doesn't have to be right now, what hearings are coming up? Because I've got my hearing for this motion is still set on calendar for September for September 30th, despite, there was a very direct minute order. And that's why I'm here. And so my hearing is going forward today, right? Okay, thank you. And then there's a motion that was filed by Luba about the amended complaints, and I have a counter motion, and that's set for October 9th, I believe. Do you mind just clarifying
Say that again?
that it's set for October 9th, that there's a hearing set for October 9th on those motions to file amended complaints?
Well, we'll deal with that.
Okay, thanks. So because I'm confused, there's so many filings trying to keep up with it all. And again, I'd rely on I think it was well briefed. If you have specific questions, you addressed the litigation privilege already, and that applies to parties and witnesses, and it's absolute. And it looks to me like the complaint is about this testimony, and I was just a witness that was asked to testify, and so I went and testified, so I'm protected by litigation privilege. And Ms. Dace is the party that requested that I testify, so that's why I threw in the invited error. But I testified, and this thing about losing her custody of her child, there's a 40-page order, and my involvement in it is actually kind of minimal. There's multiple issues that are happening, but the punchline is that it's on appeal. And so this Pewitt case, which I quote on page 9 of, I just have a quote on page 9 of my motion, is that it's not the malpractice case does not accrue, this is just quoting, accrue while the appeal is pending. And so I'm just pointing out that this SLAPP motion is that it's a matter of public interest, which is my testimony, open and public courtroom, my testimony. And then even if you overcome that, she doesn't have a cause of action that she can prevail on because my malpractice claim is not accruing and I have litigation privilege for the testimony. But again, there's multiple amended complaints, and so I don't know which one to address, and I guess that will be addressed on October 9th. And pardon me?
I said or today.
Or okay, well it could be
That's all you have, then you can sit down.
Oh, thank you. If you have any questions.
Enough. Ms. Dace, anything else you'd like to say before I rule?
Yes, Your Honor, if you could just give me a
Sure.
Thank you, I appreciate that. As far as Mr. Childs saying that his testimony is protected, under Greenberg, Trari versus Reyes, that is the controlling Nevada law, so I gave Mr. Grimes privilege, I waived privilege with Mr. Childs, I'm sorry, so he could just testify truthfully, and he did not, so he cannot, lies are not pertinent to the noticed issues, and they are not privileged, if that makes sense. I'm sorry, I'm a little nervous.
I understand. You've done a good job representing yourself. I understand the issue. So is that anything else that you wanted to say?
If the court, I would ask the court to stay on the issues rather than dismiss the case. If the court leans towards that way, once the appeal goes through, that maybe we can move forward then.
So that's a good request. What I'm doing is I'm going to dismiss. I am dismissing the case as to Mr. Childs and to the malpractice claims with him. That is dismissed without prejudice, which means that you can bring those claims again after the appeal is completed if it's not addressed fully on appeal. He has identified that, and you have identified that claim does not begin to accrue until the appeal is resolved, because the appeal really determines whether or not you suffered harm because of malpractice, right? So as to Stoffel Law Firm in Grimes, the issue really is one is the litigation privilege, statute of limitations, double recovery, but really the issue is your right to correct all those harms is through the appeal. So if they do something wrong in that other case, if they present false information, if they unlawfully conspire with your attorney, anything like that, those are things that need to be brought before that judge, Judge Almasi, in that case. And then it also goes up on appeal. So it gives that judge an opportunity to address it. That judge, Judge Almasi, issued some sanctions. And so it becomes even more difficult for me to go in and address what another judge has already addressed. And for that reason. And that's one reason the litigation privilege exists as well. Anything that's happening in the litigation has to be addressed with that judge who's handling the litigation. So as to Stoffel Law Firm and Grimes, their motion to dismiss on anti-S.L.A.P.P. is granted with prejudice on Benjamin, but not to prejudice your appeal. The case against Benjamin Childs, his motion to dismiss is also granted. As to any suggestion of malpractice, that motion to dismiss is granted without prejudice. So that after the appeal is resolved, after that's done, if that's something that survives, you can bring that case separately. Okay. The court finds that as far as it finds on the other issues, that the litigation privilege, he is acting as a witness there. You called on him to testify in that other case. Once again, if he testifies falsely in that case, that's something you have to address with that judge, and the rules allow you to present before that judge, even after judgment, you can present additional evidence showing fraud on the court, anything that happened that judge should consider to amend the order. It's a substantial order to have a child taken away and your joint custody taken away. That's why so much authority is given to that judge to review it and to receive additional evidence. The sum of this is, really this is the wrong forum for the challenge you're trying to make after your appeal is done. As to Mr. Childs, I've dismissed that claim without prejudice. Okay? Do you have any questions about that, Ms. Nace?
I did file a motion for reconsideration in front of Judge Almasi, presenting all the information and proof that Mr. Childs lied. She did not, she rejected.
Okay. So that's the purpose of the appeal then. So if you've already presented in that court, then the appeals court is what resolves at this point, and they have the ability to fix it. It's not my place to step in and tell Judge Almasi that she was wrong. Okay? Thank you very much. Ms. Ochoa, do you have any questions regarding drafting the order?
No, I'll take a stab at it, but I just want to make sure that the dismissal is non-protunct. It's as of today, so all hearings going forward are vacated.
Correct. Everything's vacated. Any questions, Mr. Childs?
No, you want separate orders for separate order for me and a separate order for Mr. Grimes, right?
Correct.
Okay.
Different.
And I don't mind sending it over to Ms. Stace, but I don't know because she's self-represented.
She certainly has the right to review it before you submit it to me.
Right.
That's all.
I will.
All right.
Thank you.
Thank you, Ms. Stace. Thank you, Ms. Ochoa. Thank you, Mr. Childs.